Welcome back to LexTalks, legal topics simplified, where we take apart even the toughest legal ideas and make them easy to understand.
Yeah, make them bite-sized, you know?
Exactly, bite-sized pieces you can really digest.
That's us.
And on today's deep dive, we're tackling something really important for any up-and-coming lawyer,
Yeah.
administrative action.
It's a big one.
It's everywhere, right? You see it from environmental rules to licensing to even disciplinary actions, say, at a university.
Yeah, you're right.
Might not sound as exciting as, a courtroom drama, but believe me, this is where the rubber meets the road when it comes to how the government actually gets things done.
Yeah, it really is the engine room of modern government. I mean, when you think about it, legislatures pass laws and that kind of sets the big framework, but the actual nitty-gritty of how those laws are actually put into practice and how they're enforced, that's all administrative action.
So it's like the executive branch taking those broad laws and turning them into, real-world action.
Yeah.
I'm starting to see why this is so important for future lawyers then.
Absolutely. You need to understand like the nuts and bolts of how these government agencies actually work, what powers they have and how those powers are controlled because it's a huge area of law and it's always growing. I mean, as the role of government gets bigger, the reach of administrative action just keeps expanding.
Okay, so let's break it down then. What exactly is administrative action? I mean, we all know about laws that are passed by, legislatures, but this seems different.
Yeah, you're right. It is different. Basically, in simple terms, administrative action is anything that the government or its agencies do to put those laws into effect and enforce them. It's like the bridge between legislation and how it's used in our lives, how the government makes things happen beyond just setting the rules.
So like if legislation is the blueprint for a House administrative action, is the construction crew actually building it?
I like that. Yeah, that's a good way to think about it.
Yeah.
It covers all sorts of activities from making regulations to issuing permits, conducting investigations, resolving disputes, even providing public services. It's a lot.
That's a lot to take in.
Yeah.
It sounds like just trying to put all the different types of administrative action into categories could get really complicated.
Yeah, you're right. It's tough. It can be a bit like herding cats, but legal scholars have come up with some broad classifications that help us get a handle on the different ways these agencies work. One really important distinction is between what we call quasi-legislative and quasi-judicial actions.
Okay, now those terms sound a little intimidating.
They do.
What does quasi even mean?
Good question. Quasi simply means resembling. So quasi-legislative actions are those where agencies kind of act like mini legislatures.
Okay.
They make rules and regulations that basically have the power of law, even though they weren't actually passed by a legislature.
So these agencies are making rules that affect our lives, even though they weren't, directly elected by the people. That seems like a lot of power.
It is a lot of power. That's why it's so important to make sure that they're accountable. But to get back to your question, yeah, these rules can have a huge impact. I mean, think of environmental regulations by the EPA,
Yeah.
or safety standards for food and drugs issued by the FDA. Those are examples of what we call quasi-legislative actions. They have the same legal effect as laws passed by Congress, even though they came from administrative agencies.
Wow. That really shows how much power these agencies have.
Yeah.
Okay, so what about quasi-judicial actions? Does that mean agencies are acting like courts?
Exactly. Quasi-judicial actions are where agencies make decisions that affect people's rights, just like a court would, for example. Imagine a student facing some kind of disciplinary action at their university.
Hmm.
They might have a hearing in front of an administrative body within the university that acts like a little court,
Yeah.
They weigh the evidence and they make a decision that directly impacts that student's rights.
So it's kind of like a mini trial within the university itself.
Yeah, precisely. And just like in a regular court, fairness is super important. These agencies have to follow principles of what's called natural justice, making sure that individuals are given a fair hearing and that decisions are made impartially.
Now, there was another category you mentioned, purely administrative actions.
Mm.
What are those all about?
Yeah, those are the actions that don't quite fit into those other neat categories. Purely administrative actions are the everyday things that keep the government running smoothly, issuing permits, collecting taxes, providing public services. They may not involve creating new rules or making judicial decisions, but they're super essential for the basic functioning of government.
So it's like all the behind-the-scenes work that we kind of take for granted.
Absolutely. Think of it as like the circulatory system of the government. It's not always exciting, but it's what keeps everything flowing.
So we've got agencies acting like mini legislatures, making rules, agencies acting like courts, deciding on individual rights, and agencies doing the day-to-day tasks of government. Yeah, it's a lot to process, but I'm starting to see how understanding these different types of administrative actions is key to understanding how the whole system works.
You're getting it, and that brings us to another really important question.
But before we move on, I have one more question about these different types of actions. Is it always clear-cut which category a specific action belongs to? I feel like there might be some gray areas.
Oh, you're absolutely right. It's not always so black and white. Sometimes an action might have parts of both quasi-legislative and quasi-judicial functions, or an action that seems purely administrative on the surface might have big implications for individual rights. It's one of the things that makes administrative law such a challenge and so interesting.
Okay, so these categories are helpful guidelines, but the real world can be a little bit messier.
Definitely.
And what was that crucial question you were going to ask?
Well, we've talked about all these different types of administrative actions and how much power agencies have, but that leads to another question. Why do we need to control administrative action in the first place?
Yeah, that is the million-dollar question. It's all about finding a balance. On the one hand, we need agencies to be efficient. We need them to be effective. They deal with some really complex issues, and we want them to be able to, get things done.
Right. We don't want them bogged down with, bureaucracy and red tape.
Exactly. But on the other hand, we can't just let them do whatever they want. I mean, imagine these agencies making decisions that affect, your rights, your freedoms, even your livelihood without any kind of checks and balances. That's why we need control.
So it's about making sure that power is used responsibly and that people have a way to challenge decisions that they think are, unfair or maybe even illegal.
That's exactly. It's about making sure that those agencies operate within the law, that they don't abuse their power, and that individuals have some recourse, some way to fight back. It's about protecting individual rights and upholding the rule of law. Makes sense. How do we actually do that, though? What are the ways to control administrative action?
Well, there are several main methods, each with their own, pluses and minuses. We can kind of think of it as a three-pronged approach.
Okay, I like that.
Legislative control,
Okay.
executive control,
Okay.
and judicial control.
All right, a three-pronged approach. I like that it suggests a system of checks and balances. So let's break down each of those, starting with legislative control. What does that actually look like?
Okay, so think of the legislature as the parent setting boundaries for their, administrative children. They have the power to actually create agencies in the first place through legislation, defining what they can do, setting the rules of the game, and they can also change or even repeal those laws, tightening or loosening an agency's leash as needed.
So it's about establishing those ground rules right from the start, making sure those agencies stay in their lane.
Exactly. But legislative control goes beyond just the initial setup. Legislatures also exercise ongoing oversight through parliamentary committees.
Right.
These committees act as watchdogs, scrutinizing what agencies are doing. They hold hearings, they summon officials, they demand explanations, like keeping them on their toes.
Yeah, making sure they're accountable. Are there any specific examples of these committees in action?
Sure, absolutely. Take the Public Accounts Committee, for example. They dig into the financial dealings of government agencies, making sure that taxpayer money is being spent properly,
No.
responsibly and efficiently. They can uncover waste. They can pinpoint inefficiencies and even recommend changes to the law to prevent future problems.
So it's not just about preventing the abuse of power, but also ensuring good governance and efficient use of public funds.
You got it. It's about making sure that agencies are working effectively and in the public interest. So that's legislative control. Now let's move on to executive control. This is where the government kind of keeps its own agencies in check, right?
It seems like it would be in the government's best interest to make sure that its agencies are running smoothly and not causing any trouble.
Of course, think of it as like a hierarchy of supervision within the executive branch itself. Agencies report to departments, departments report to ministers, and ministers are ultimately accountable to the prime minister. It's a chain of command designed to ensure that agencies are doing their jobs effectively and in line with government policy.
So there's pressure from the top down to make sure everyone is on the same page and that things are running smoothly.
Exactly. But it's not just pressure. There are actual mechanisms for executive control departments can issue directives to agencies, laying out policy guidelines and priorities. They can conduct audits to really scrutinize what agencies are doing, making sure they're following the rules. And if an agency is really out of line, the government can take disciplinary action against those public servants.
So it's not just about, gentle nudges and suggestions. There are real consequences for agencies that don't follow the rules.
You bet the government has a real interest in making sure its agencies are functioning well, ethically and legally. They don't want scandals or controversies that could damage public trust. Okay, so we've got legislative control. Setting the ground rules and providing oversight, executive control, keeping things running smoothly within the government. Now, let's talk about judicial control. This is where the courts come in, right?
The court's acting as a check on the power of those agencies, making sure they don't overstep their bounds or make decisions that are unfair or unjust.
Exactly. And they do this through various legal tools, like what we call writs, for instance. A writ of certiorari allows a higher court to review the decision of a lower court or an agency.
Okay.
It's like saying, hold on, let's take a closer look at this and make sure everything is above board.
And writ of prohibition is about stopping an agency from doing something it's not supposed to do right.
That's right. It's like a legal restraining order against an agency that's trying to exceed its authority.
So it's about preventing unlawful action before it happens. What about those other writs we talked about earlier, mandamus and habeas corpus? How do those fit in?
Well, a writ of mandamus is about forcing action. If an agency is dragging its feet on something it's legally obligated to do, a court can issue a writ of mandamus to make them do it. It's like a judicial kick in the pants.
And habeas corpus is about protecting individual liberty.
Exactly. It's a fundamental safeguard against unlawful detention. If someone is being held unlawfully, they can file a writ of habeas corpus to challenge their detention and demand their release. It's a cornerstone of legal systems that value individual freedom.
So we've got these different writs, each with its own specific purpose, all aimed at keeping those agencies in check and making sure that people's rights are protected.
Exactly. But it's not just about this. Writs courts can also review the actual decisions made by agencies, making sure they're not arbitrary or capricious or unreasonable. They can look at the evidence, the reasoning, the procedures that were followed, and overturn decisions that don't meet the legal standards.
It sounds like the courts have a crucial role in maintaining that balance between efficiency and individual rights.
They do, but judicial control isn't the only mechanism at play. There are other important players in this game of checks and balances.
Like what? I'm curious. Tell me more.
Well, for example, we have what's called the ombudsman system in many countries, including India. There are independent ombudsman offices that investigate complaints against government agencies. It's a way for people to seek justice outside of the traditional court system.
So if you feel like an agency has done you wrong, you can go to the ombudsman for help. It's like having a neutral third party look into your complaint.
Exactly. It's a less formal and often less intimidating option for seeking accountability. The ombudsman can investigate the complaint, make recommendations for corrective action, and even issue reports that highlight systemic problems within agencies.
That's great. It gives individuals a voice, a way to fight back against, bureaucratic wrongs. Are there any other mechanisms for controlling administrative action?
We also have tribunals. These are specialized bodies set up to handle specific administrative issues, often with a more streamlined and efficient process than regular courts.
So it's like having expert judges who really get the specific issues involved.
That's the idea. They can offer more focused expertise and often resolve disputes more quickly than the usual court system.
This is all so interesting. And it's amazing to see all these different ways to make sure that administrative agencies are following the law and that people's rights are being protected. It's like a whole complex system of checks and balances.
It really is, and it's a system that's always changing, as new challenges pop up and new solutions are found.
I bet. But with all this talk about controls and legal remedies, it makes me wonder, how does all this work in real life? Can we look at some specific examples of how these principles play out in practice?
Yeah, it's one thing to talk about, these legal theories, but it's seeing how they actually play out in the real world that really makes it sink in.
I agree.
I'm ready for some, case studies. All right, let's dive in some landmark cases that have really shaped administrative law in India. These aren't just, old legal precedents. They're stories about real people fighting for their rights against, powerful government agencies.
Okay. I'm ready for some legal drama. Where do we start?
Let's jump right in with the case of A.K. Krapak versus Union of India.
Okay.
This one goes all the way back to 1969.
Wow.
But it still has an impact today. It's a classic example of why natural justice is so important in administrative proceedings.
Natural justice. That sounds pretty fundamental. Remind me what that means again.
Basically, natural justice means fairness. It's the idea that everyone deserves a fair hearing, even when they're dealing with government agencies, not just, in a traditional court setting.
Okay. So it's about ensuring that the process is fair, even if it's not like a formal courtroom. What happened in this Krapak case?
Well, Krepak was a highly qualified candidate for a really top forestry position. He went through the interview process, but there was a bit of a problem. The selection board included someone who, let's just say, might have had their own reasons for wanting a certain candidate to get the job.
Oh, that sounds like a conflict of interest.
Yeah, you got it. Krepak argued that this situation created bias. It prevented him from having a fair and impartial chance. And guess what? The Supreme Court agreed with him.
So even though it wasn't a typical courtroom trial, that principle of fairness still applied.
Absolutely. The court recognized that administrative bodies that perform quasi-judicial functions like this selection board, they have to follow the principles of natural justice. They can't just rig the system in their favor.
That makes sense. It wouldn't be fair for someone to be judged by a panel that's already biased against them. So what happened to Krypok in the end?
The court decided that the whole selection process was tainted, and they ordered a new one. One that guaranteed fairness and impartiality. This case set a really powerful precedent. It sent a clear message that individuals deserve a fair hearing, even in administrative settings.
It's like a David and Goliath story. The little guy taking on this big, powerful agency and winning it gives me hope. For anyone going up against a bureaucratic giant, what other landmark cases should we know about?
Okay, let's fast forward a few years to 1978 and the really important case of Maneka Gandhi versus Union of India. This one is a real game changer when it comes to judicial review and the protection of fundamental rights.
Maneka Gandhi, that name rings a bell. Wasn't this the one about a passport?
Yeah, you're right. The government took away Maneka Gandhi's passport, claiming it was for the public good.
Hmm.
But the court wasn't convinced. They saw through that kind of vague explanation and decided that the government's actions were arbitrary and violated her right to personal liberty, which is a fundamental right guaranteed by the Indian Constitution.
So the government can't just take someone's passport away without a good reason and a fair process.
No, they can't. The court made it very clear that even though the government has broad powers, those powers aren't unlimited. They have to be used according to the Constitution, respecting individual rights and following due process. This case was about so much more than just a passport. It was about setting limits on government power.
Wow, that's a major victory for individual rights. It reminds us that we have a constitution for a reason, to protect us from the government overstepping its bounds. What was the lasting effect of this case?
Well, the Maneka Gandhi case really broadened the scope of judicial review in India. It established that courts can scrutinize not only the procedures that administrative agencies follow, but also the actual content of their decisions, making sure they don't infringe on fundamental rights.
So that's a huge check on administrative power.
hmm
It means even if an agency follows all the procedures perfectly, their decision can still be thrown out if it's deemed unfair or unreasonable. What a landmark decision.
It really is okay for our last case study. Let's switch gears a bit and look at Delhi administration versus VC Shukla. This case highlights the role of the legislature in keeping administrative action in check. This one involved allegations of corruption against a former minister.
Corruption cases always make the news. What was the main issue here?
The government created a commission of inquiry to look into these allegations, but the powers given to this commission were challenged in court. The question was, could the legislature, in this case Parliament, give such broad investigative powers to a commission? Was it a legitimate delegation of power, or was Parliament giving up its own responsibilities?
So it's about that principle we discussed earlier, the legislature setting boundaries for agencies.
Exactly right. The Supreme Court got involved and made a really important distinction. They said that while the legislature can delegate powers to agencies, it can't just abandon its core legislative functions. The delegation has to be within the framework of the law, and the agency's actions have to be consistent with the legislature's intention.
It's like the legislature lending out its tools, but making sure they're used for the right job, not for something else entirely.
Exactly. In this case, the court upheld the powers of the commission, but emphasized that those powers had to be used lawfully and with respect for the principles of natural justice.
This case really illustrates how different branches of government work together to keep administrative action under control. We have the legislatures setting things up, the executive branch carrying out those actions, and the judiciary making sure everyone plays by the rules.
It's a sort of intricate dance of powers, all working towards that balance between effective government and individual rights.
Wow, these cases have really made administrative law come alive. For me, it's not just abstract ideas anymore. It's about real people,
Yeah.
real struggles, and real wins.
And as future lawyers, you'll be the ones using these legal tools, advocating for your clients, and shaping the future of administrative law. Remember, it's a field that's always changing, always developing, but the core principles stay the same: accountability, transparency, fairness, and protecting individual rights.
Those are principles worth fighting for. Thanks for joining us on Lex Talks, where we make even the trickiest legal topics easy to grasp and interesting to explore.
And don't forget to subscribe for more deep dives into the fascinating world of law. Until next time, keep those legal minds sharp.